think about the First Amendment that guarantees freedom of speech. Think about it in the context of the Constitution. What's its role in terms of the Constitution?
No question. There is a right to freedom of speech. It is an enumerated right. If you look, however, at how that right was enforced, you will find that the Supreme Court has held that it includes or it implies a right to freedom of association, because free speech doesn't mean much to people who do not have positions of power or large amounts of money to purchase broadcast time and so on. Without the power to come together and have someone speak for them, their right to speak really isn't worth much. It makes perfect sense to say, yes, there is a right to freedom of association. But remember that what it is, it's a right that is recognized in order to make practical sense, in order to give practical value to the general right of speech.
So, in adopting the First Amendment, the role is to give all of us the right to be a participant in the debate, because the First Amendment guarantees freedom of speech, freedom to peaceably assemble, and freedom to petition our government to redress grievances, all secured by the First Amendment.
Nobody in his right mind in 1791, when the Bill of Rights was adopted, ever thought that freedom of speech and freedom of association and so on, the First Amendment rights, would carry with it a right to join organizations. It never crossed their minds. If you had said to somebody in 1791, after the Bill of Rights was ratified, does this speech clause cover anything but speech? They would have looked at you and said, no speak of English. It says speech. But we know that, in fact, if you limit it that narrowly, it's not going to mean very much.
At the end of World War I, the Supreme Court issued 4 decisions that arose out of the Espionage Act, an act that criminalized writing and action that undermined the government and the government's efforts in World War I. And the 4 cases arose out of pamphlets and circulators that had been distributed that were critical of the government's role, encourage workers to strike, not manufacture munitions, and oppose the draft. And in the first 3 of them, in January of 1919, Oliver Wendell Holmes, that famous judge, wrote for the court upholding the convictions based on these circulars. 10 months later, in a case called Abrams, the court upheld the conviction, again based on circulars, and Holmes this time was in dissent. And the key point that Holmes made is the following: but when men have realized that time has upset many fighting face, they may come to believe that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of thought to get accepted in the competition of the market. That, at any rate, is the theory of the Constitution.
You look at the text of the First Amendment, Congress shall make no law abridging the freedom of speech and so on. No law sounds pretty tough. but in fact, everybody recognizes, conservatives, liberals, it's not an issue, that there are some laws that Congress can make that in a practical sense do limit the freedom of speech. No one doubts, for example, that if an individual was poised with a microphone in his mouth to divulge America's nuclear secrets, that he could be stopped without violating the First Amendment. If speech always wins, even though it's atomic secrets that are going to be broadcast to our enemies, it's easy to write the decision. Speech always wins. But it doesn't. Most of the time it does, because it has very high value, but it doesn't always. Liberty doesn't always trump equality, or equality always trump liberty, and so on. An example that probably a lot of us have in our minds a lot is the Supreme Court's decision the year after I stepped down on political campaign contributions by corporations, the so-called Citizens United decision. Should corporations, in effect, be subject to the limitations on political expenditures that they were and, in fact, had been subject to for a century? There was a play of constitutional values going on there. If the Supreme Court took a liberty model, the liberty model of free expression was, yeah, corporations can spend all the money they want to in the world. If they took an equality model, they would say there's got to be the possibility of a limitation on corporations so that they do not drown out other speech. The Supreme Court and Citizens United went with the liberty model. But these kinds of conflicts in values are simply part of the Constitution, and you can't say that you can solve them simply by reading fairly the text, because if you read fairly the text, you'd have to conclude you can have it both ways all the time, and you can't. And the writers of the Bill of Rights knew that just as well as we do. So there are tensions that have simply got to be resolved, and the Constitution does not have a provision in there that tells you how you're going to resolve them.